This is a special report from True Crime Today and the Hidden Killers podcast.
Chad Daybell back in the Fremont County Court today. Motions filed by John Pryor, Daybell's defense attorney, and prosecutors Lindsey Blake and Rob Wood regarding a change of venue for the trial, cameras in the courtroom, and taking the death penalty off the table, amongst other issues to be discussed today. Let's go right to the courtroom to hear the audio.
County prosecutor who's also been appointed as counsel on this case. We are holding hearings on various motions scheduled for this morning. Before we get started, the court will note there is an order governing courtroom conduct that's in effect in this case. According to the terms of that order, other than what's been specifically authorized by the court, there's not to be any unauthorized photography or recording of these proceedings. And if you have any personal devices that will go off or make a sound, please make sure those are silenced. If they do go off during the proceedings, I'll instruct the bailiff to take those and hold them until we're concluded with our motions this morning. So scheduled before the court are various motions, including a motion as it relates to a reconsideration of the court's previous order on video and photographic coverage of the trial in this case. That's scheduled to be heard this morning. We've also got the state's motion to amend the indictment, the state's renewed motion to reconsider change of venue. We've got the defendant's motion in limine, requesting a motion in limine to limit the state to consistent arguments. There's also two additional motions filed by the defense relating to a request to strike the death penalty in this case. So we'll take these matters up in the order I just announced them. So let me just inquire first, starting then with the reconsideration of video and photographic coverage. Is the state ready to proceed with that motion?
Yes, Your Honor.
And who will be arguing that?
I'll be arguing that motion.
Very well. And then is the defense ready to proceed on that motion? Yes, Your Honor. All right. I'll note also on that motion, the court will permit and has considered briefing that was submitted by interested parties. Wendy Olson representing those interested parties who will be allowed to submit argument for today's hearing. Is Ms. Olson present here?
I am not.
Thank you. And you'll be presenting argument today in addition, is that correct?
Yes, Your Honor.
All right. The court will permit that as well then on the motion. So we'll start then with procedurally on the motion. The court had entered a order in the what used to be the companion case of 22-21-16-24 State versus Lori Vallow, and that applied to both cases. The court thereafter had concluded that when that trial was complete, the issue of coverage would be reconsidered here. Mostly for the reason that there was a mutual request in the Lori Vallow case, which the court considered, and the parties are in a different posture here where the defense has requested that the court permit photography or video of the trial here. Mr. Pryor on behalf of his client, and we're at different proceedings, a different case now, and that other case has been concluded. So based on that, the court mentioned to counsel in a status conference that we would address the issue today. And then I issued an order on October 11th that we would hear argument on the issue today concerning camera coverage of this case continuing, as well as the trial that's scheduled for March of 2024. So at this time, the court would note I have reviewed the briefs. I'll begin with the state's argument on the issue here. After that, I'll hear from the defense, Mr. Pryor, and then finally after that, Ms. Olson, if you'd like to make any argument on behalf of your clients, you can do that. Mr. Wood.
Your Honor, respectfully, I'd actually ask that we reverse that order. This is technically the defendant's motion, and then the interested party agrees with the defendant. The state is in a responsive posture. We'd ask to be able to go after them to be able to respond. That being said, if you want me to go first, I can go first. I just think that would be the appropriate manner to proceed in.
All right, and I don't mind switching the order given that. Mr. Pryor, your thoughts?
Well, Judge, my thoughts are simply this, is that unlike the change of venue, which was the prosecuting attorney trying to have a court reconsider a motion without any lawful authority, because in the venue there is no lawful authority for them to hear a motion to reconsider. In this particular case, it was the court's own initiative that said that given the posture that they would do a motion to reconsider, and the court is well within its right to do that. In essence, what it is, Judge, is it's a first-time motion to allow cameras, and as such, I think that it's proper that the state go first and followed by the defense and Ms. Olson.
All right. Quite frankly, I'm not sure that the order matters that much in terms of how persuasive the arguments would be. I would note it was the court that raised the issue sua sponte in its order to review the issue given where we're at. Mr. Wood, I'll hear your argument at this point, and then I will hear the response from the others. I'll allow a rebuttal, however, after they've made their arguments. So if you'd like to present argument now, you can.
Very well, thank you, Your Honor. So the motion before the court is whether or not we allow live broadcasting or cameras into the courtroom. And I want to start out, I understand these are adversarial proceedings. We do not, the state does not see the media in any way as an adversary. We are grateful for the media. We respect the media. There's a reason why the right to a free press is in our Constitution and one of the first things mentioned in the Bill of Rights. We understand they have an important role in preserving government transparency. They have an important role in informing the public. And so we do respect them. This argument is not at all about whether or not the media should be allowed in the courtroom. They should be allowed, and we're glad they're there. In terms of broadcasting the trial, and the state at least is going to address broadcasting the trial and broadcasting any further pretrial hearings. We shouldn't fix what isn't broken. This court made a very good decision. I believe it was in September or October of preceding of last year. And we think the court was correct when it made that decision. We think that that decision led to more professional proceedings and helped in preserving the rights of the parties to a fair trial. Again, we're not arguing that the media should not be allowed in the courtroom. In our brief, we talk about that. The right of the public and media is important in the courtroom. This specific issue is addressed in an Idaho Court Administrative Rule 45. This court has sole discretion over this matter. It's not even appealable by any of the parties. So the state has raised these issues several times. We actually raised this in the previous case before a preliminary hearing. Our concern, I'm going to talk quickly about pretrial hearings. Pretrial publicity can impede the ability of the parties to a fair and impartial trial. This cannot be denied, and it rose its head in the last trial. Individuals who had seen specific media programs were automatically cut from the jury. We expect that issue will be raised again. And while the state doesn't necessarily agree with a wholesale cutting those individuals out, we understand the concern of when someone has consumed too much media about a case, that it may make it difficult for them to render a fair and impartial verdict. And so in terms of at least pretrial hearings from here until the trial, the state's biggest concern there, and this might be our biggest concern overall, is if any of those hearings deal with evidence that we will be discussing at trial. We believe that by broadcasting it, it makes it even more easy to consume by the public, by the mass public, and creates further issues when picking a jury. And again, we've already seen it. This isn't a hypothetical. It's happened. There's no reason to believe it won't happen again. Again, we're not saying the media shouldn't be allowed to report. They should. That's important. There is a difference between reporting, though, and the ability to live broadcast. And there's nothing in the law that states that they have to be able to live broadcast. In terms of trial, and I don't want to regurgitate everything that all the issues I raised in my briefing. There's a lot of people who are called to witnesses in this case who want nothing to do with it. They're not there because they want to be. They didn't get dragged into a triple murder, horrible case, a sordid case, because they wanted to be a part of it. And the state is concerned, and we think validly so, about the effect on witnesses of knowing their face is being plastered on TV for millions of people to see. It's already hard enough to get on a witness stand, be placed under oath, and then to be direct examined, to be cross-examined. Trial gets aggressive. And then to have that added pressure of knowing my next door neighbor can watch this. The people I go to church with can watch this. It's not conducive, especially in a case like this, with fair trial for either of the parties. We understand that the defendant has a different position on that. We believe strongly that having live broadcasting this trial only makes it more difficult to get to the truth of the matter. As stated before, we do not believe that visual broadcasting is necessary for a transparent and a public trial. We believe in an open and public trial. Transparency does not require mass publicity. And there's no rule, there's no law that says that it does. And I would note, and I put this in my brief, at the last trial, at Lori's trial, there was a lot of reporting, and it was minute by minute. I called it live tweeting. I don't know if there's a specific other phrase for that, but where multiple reporters in the courtroom or in the auxiliary room were able to live tweet, and that was great. I fully support that, and in as much as we are able to follow it, it appeared to be very accurate and timely. And so the public, the interested public, was able to follow by the minute what was happening in the trial. They didn't need to watch it. They still got that information. And again, as far as the state could tell, it was accurate information. It was a job well done by the individuals reporting on the case. And so not only that, there's a transcript. People can obtain the transcript. There was an audio recording that was provided at the end of each day. And so in terms of a transparent and public trial, we don't have to point cameras in people's faces for the trial to be open, transparent, and public. I would quickly note, the state is aware, many of the victims in this case feel differently than the state. I know there was news articles about that last time. We don't technically represent the victims. We respect them and their desires, and it's appropriate for the court to know they don't necessarily agree with us on this. And so if we keep the status quo, if we keep it where it's at, there's no risk of a non-public trial. There's no risk of a non-transparent trial. The state doesn't see an upside to bringing cameras into the courtroom. It worked well the last time. Again, we shouldn't fix what isn't broken. And I put this in my brief, and if the court decides to change its decision, we respectfully request a few things. We would ask, and this hasn't been an issue lately, and it wasn't an issue at the last trial, but just, I guess, preemptively, we would specifically request that no media microphones be placed at counsel's table, as took place in some of the other pretrial hearings. We believe that violates Idaho Court Administrative Rule 45C, or at least has a very grave ability to violate that rule. We would ask that the court consider alternatives to live visual broadcasting, such as still photography. And should the court allow visual broadcasting, we would ask that the court essentially retain tight control on that, at least while it's being done. As this court is aware, once video is made and public, the court loses any and all control by rule over what happens with it. But we would ask that the camera placement be limited. We think a good model would be Ms. Vallow or Ms. Daybell's sentencing, in which I believe there was a camera on the court and one camera pointing at the parties. There was no zooming in on attorneys, on witnesses, on victims. And so we would ask that if the court does change its decision, that it do so within that framework to maintain the fairness of the trial. Again, we do not believe that live broadcasting is necessary. Thank you.
All right, thank you for the argument, Mr. Wood. Mr. Pryor.
Judge, the primary reason for Mr. Daybell requesting the cameras is to allow his family to view the proceedings. They would like the opportunity to watch on TV and to see how the trial transpires, and those children that aren't going to be witnesses would like to be able to do that. It's extended family as well. That's our primary reason for doing that. I'm concerned about live streaming because that allows, in my opinion, less control. Cameras, in addition, in the courtroom, we lose a little bit of control as well. But I'd be more concerned about a cameraman who's, while this thing has been proceeding, has snapped 1,000 pictures of me and Chad while we're sitting here. That's a bigger concern for me than the actual cameras. We can't control what this cameraman's doing and the pictures he's taken. He's been snipping along, and I'm sure I'll be seeing them with Mr. Eaton's website later today or tomorrow. The court, however, can put some conditions on a live camera. And on a live camera, like Mr. Wood pointed out, and I wholeheartedly, and quite frankly, Mr. Wood, I agree almost with everything you say. He makes a good, valid argument, Judge. However, the overriding concern is that when our founding fathers started the process of deciding that there would be a public trial, we didn't have cameras. We didn't have ability to broadcast this. And the idea behind a public trial was that if you brought allegations against someone and they wanted to answer those allegations, they should be able to do that in a public forum. And the stay of media and the amount of attention, and and I do disagree with Mr. Wood. East Idaho has been saturated with media attention on this case, but the reality is this is a national case. It has garnered tremendous attention, and a public trial is just not limited to people coming from Fremont County to sit in the courtroom and watch the proceedings. And having sat through the entire trial of Lori Vallow and watched the entire proceeding, there were issues with the live feed. I'm opposed to the live feed. I just didn't think it worked. It wasn't pragmatic. It wasn't practical. I think that let's use the professionals who know how to do this. I don't like the idea of a camera being pointed in my face for what's going to end up being 8 to 10 weeks. I dislike even more a photographer taking pictures of me while we're sitting here. And I'd much rather have a cameraman with that. And Mr. Wood pointed out some of the restrictions that we could apply. And I agree with what he said. No mics at the tables. I guess if you have to point the camera at Mr. Daybell and I, go ahead, and Mr. Wood and his group as well, and at the witnesses. But part of the reason behind a public trial, Judge, is accountability. And that's a big overriding factor. And when you're talking about due process and people having a fair right to a public trial, accountability is important. And as much as I don't like the idea of being on live TV, national TV, and I don't like the idea of it at all, the reality is it keeps everybody honest. It keeps the system honest. It keeps the witnesses honest. It keeps everybody honest. And and I'll disagree with Mr. Wood in just this regard. The fact that you have a camera on you, the fact that people are watching this in a public, much like when our founding fathers, you had to answer questions in a public forum, that makes the system honest. And that really is what the driving force, Judge, is allow the public to see this in an honest way, be able to see the entire evidence, not what press releases that people are releasing, not what certain news media report. Let's allow the public to see this in a public way and allow what really is should be a public trial. And again, allowing Mr. Daybell's family to review the proceedings. You could imagine, Judge, that if they show up to court, they would be inundated, whether it was here or anybody else, with the media hounding them and the victims as well, and everybody else who's involved in this, allowing them people to watch this in a public setting. There is one caveat. By doing this in a public with live cameras, Judge, that does create a concern for whether or not witnesses are watching the proceedings. And I guess I don't know how the court would address that, and that's something the court does need to look at. That doesn't change my position that I believe it should be a public hearing with cameras, but controlling how witnesses are limited in watching the media, and maybe the prosecutors and I could work out something with all of our witnesses saying, absolutely no opportunities to view this. If the court allows us to be a public trial with cameras, there's going to have to be some courtroom order that advises all of the witnesses that they are not under any circumstances to review the proceedings or view the proceedings. So that is a concern of mine, but I still stick with our original position that we need to have cameras in the courtroom, Judge. Thank you, Your Honor.
All right. Thank you, Mr. Pryor. Morning, Ms. Olson. I'll note now we'll hear argument from Attorney Wendy Olson, who's representing EastIdahoNews.com, the Idaho Statesman, Idaho Press Club, and States Newsroom, doing business as Idaho Capital Sun. Brief's been filed. The court's reviewed that, and if you'd like to present argument in support of your position, you can do so at this time.
Thank you, Your Honor. And thank you for allowing my clients to be heard this morning. As the court noted, the clients are 3 Idaho-based news entities, and then the Idaho Press Club, which is an association of journalists who work on a variety of First Amendment matters to ensure that they can have complete coverage of matters of important interest in the state of Idaho. Your Honor, the entities request the ability to have live audio and visual coverage of the proceedings in this case, consistent with Idaho Court Administrative Rule 45, in a way that will allow the defendant and the state to have their constitutional interests protected, in a way that is designed to respect the privacy concerns of jurors and the sensitivities of witnesses, and to really observe the dignity of the courtroom. And I think, Your Honor, that the media entities that are before you here have done that in other cases, and they would want to work with the court on any restrictions the court thinks is important to maintain the dignity of the courtroom, to ensure that sensitive witnesses, maybe only their audio is heard at the time. They would want to work with the court to ensure that whatever guidelines the court imposes, that they would follow. But they think it's important to have cameras in the courtroom and have live audio visual coverage of the proceedings for several reasons. Primarily among them, Your Honor, the point that Mr. Pryor touched on is that we are in an age now where visual coverage of just about every aspect of public life is there, where people really have the opportunity to see with their own eyes, not by sitting in a courtroom, but by sitting in their living rooms or sitting in their offices to watch those proceedings. The Kyle Rittenhouse trial had extensive coverage, TV coverage. Certainly the Derek Chauvin case did. That started out of COVID, but the judge after that realized the importance of having cameras in the courtroom. And then more recently, the Alex Murdaugh trial in South Carolina, where the coverage there was basically from the opening of the trial through the sentencings. And I think that the coverage in those cases showed how, with guidelines from the court, it allows the public to observe firsthand what goes on in the courtroom. I know the court indicated that you read our submittals, our pleadings. I would also ask the court to take particular note of Rebecca Boone's declaration and where she talks about she's worked with Idaho courts, Idaho journalists, the law school to try to improve coverage of our court system. We learn a lot in the public about the executive branch and the legislative branch, but less is known about the judicial branch and how it operates. And I think it's important for people to be able to see firsthand what happens in a trial. How is evidence presented? I think it's important to the point that Mr. Wood raised that it's important for them to see the impact that participating in a trial demands from the people who participate in it. It is no doubt, Your Honor, that the criminal justice system, the system that I participated in for most of my legal career, is very hard on the participants. It demands a lot of people. It demands a lot of the lawyers, the court, of the jurors, of the witnesses, of the family members. And I think that covering the proceedings live will allow the public to understand that better, because it is still a relatively rare thing for people to have firsthand involvement in any aspect of court proceedings. I think secondly, Your Honor, why it would be important and helpful to the court to have live audio and visual coverage is it would reduce the demand, frankly, for space in the courtroom. It's my understanding that the attendance at this hearing by the public is less than in past hearings, and maybe that's because the court elected to broadcast this live through the YouTube channel that the courts have used. Certainly, that will help the court with security and with other administrative needs and getting the trial done in a way that is most efficient. And so we think for that reason as well, it would be important to have live audio and visual coverage of the proceedings. And finally, Your Honor, with respect to how that is done, again, the media organizations want to make sure that they are working with the court on all of those things. And I know that the proceedings are being done through the court's technology today, but I would invite the court to not do it that way at the trial if the court allows visual proceedings. And that's really for several reasons, Your Honor. First, it is because the journalists who are experienced camera operators, typically who will do the pool reporting, they have more sensitive cameras, better cameras, and more sensitive microphones that could be placed, not at counsel table, but somewhere else if that is the court's direction. In addition, Your Honor, the court would not have to worry about whether or not there are any technical glitches if the cameras are being operated by the pool camera reporter. Of course, neither the parties nor the court nor the jurors nor anybody would want to have interruptions during the proceedings because there was some glitch in the technology. And then I think, Your Honor, again, with having the members of the press who are experts in operating their camera, they would work with the court to ensure that there isn't anything unnecessarily intrusive if they were the ones to operate the equipment, as was done, I think, at Ms. Vallow's sentencing. And so I think for all of those reasons, Your Honor, our clients would like to see the live audio and visual coverage of the proceedings. I well understand, too, both Mr. Pryor's and Mr. Wood's concerns about witnesses watching things that they should not watch before they testify. There's nothing sort of less comfortable as a prosecutor to know your witnesses have received outside information, and then that comes in at cross-examination. And of course, we want to make sure that jurors aren't watching the proceedings. With respect to the jurors, Your Honor, and them reading coverage of the case once they've been set, that's a concern in every trial. The court gives firm instructions about that. And I think as media has evolved, the court's instructions on those issues have had to change over time to include, for example, social media. I know in the federal courts, there's a social media instruction that's given all the time now about don't look at social media when you're a member of the jury. And this court can certainly craft instructions that would cover all of the concerns the court would have with respect to the jurors potentially watching anything that comes from the live audio and visual coverage of the trial. Of course, hopefully they wouldn't be watching while the trial was going on. And then, Your Honor, with respect to the witnesses, it really was incumbent upon the parties, and Mr. Pryor alluded to it, to speak to their witnesses and firmly instruct them not to watch and not to be influenced by any other evidence. It's no different than telling them don't talk to other witnesses about their testimony. It's important that their testimony be from their own independent recollection. And those are challenges that are present in every kind of case. And here they're even more so because of the prior trial of Ms. Daybell. And so we would ask the court that in considering those factors, do the things that the court and the parties typically do, which is to give very firm instructions. Thank you, Your Honor.
All right. I do have a few questions for you, Ms.
Sure.
Wilson. Reading through your brief, you go through some policy arguments about why it's important to have cameras in the courtroom for these proceedings. One of your captions is it will help enhance the public's understanding of court proceedings and promote respect for the rule of law. I'll note in my background, I did some federal criminal defense work. I was a CJA attorney for about 15 years, and I believe you were the U.S. attorney for Idaho during the time I was CJA attorney. In the federal courts, they simply have a rule 53 that there is no permitting of any photographs, any video at all in any federal proceeding. Is that your understanding of how the federal system works?
It absolutely is, Your Honor, and I'm cautiously optimistic that that rule will be changing some. I think it takes sort of a major case with a lot of public interest to move things that direction, and I suspect that the federal charges pending against Donald Trump and others, there is now a lot more just discussion in the media about changing that rule. One of the things we cited for the court was a poll about people wanting to see live coverage of oral arguments in the Supreme Court. I understand that appellate arguments are different animals from criminal trials, but I think the federal system is far behind the state system in terms of allowing coverage of what goes on in trials.
Okay, well, I want to understand that because Idaho leaves it at the discretion of the judge under Rule 45. Some other states want cameras in and have rules governing that. The entire federal system completely bans cameras, and there are high-profile, important criminal cases of great public interest occurring all the time in the federal system. Would you agree with that?
I agree, Your Honor.
And in all of those proceedings, there are never cameras because it's prohibited by federal rule. And so the policy arguments that the public is not going to have confidence in this case or an understanding of what's happening. I just wonder how that's squared with whatever policy drives the federal courts to just simply disallow cameras and take it out of the judge's hand. Don't you think, in fact, the public can still have that same type of confidence in the proceedings and understanding if they want to come and sit in and watch a trial as they do in any federal case?
Yes, Your Honor. I think certainly people who come and watch trials and see sort of firsthand what is going on, and we certainly had those in the federal, we had people who were just sort of trial watchers who would come and watch every trial, and particularly the ones that had a little bit more notoriety, and certainly those individuals well understood what was going on in the courtroom. Not everyone can do that in every case, as Mr. Pryor has outlined here. The family members of Mr. Daybell are not able to travel to Boise for a 10-week trial, and I understand there's a motion pending to change that, but for now in Boise. And I think obviously the federal government is not always ahead on policy issues of state courts or state governments on anything. And I think, Your Honor, my understanding is the federal rule is largely driven by the federal judiciary and wanting to ensure there are no cameras in the courtroom. And I think that will be changing as well, Your Honor. I think we're in a day and age where it is just the case that people want to see it with their own eyes. And federal courts are behind the times on that. And so there's a lot more work that needs to be done by people in the federal system, whether it's judges or former U.S. attorneys or criminal defense attorneys, to be able to articulate what goes on in those criminal courts. And there just isn't that I don't think as good of an understanding. And I do think there have been concerns expressed about outcomes in criminal cases and what it means. And there's a lot less direct information available for people to base that on.
Well, Ms. Wilson, I really appreciate your comments on that. It's really interesting to hear your perspective, having been on both sides of state and federal litigation and this issue. Clearly, there are policies in place in our state courts that maybe are different than they are in the federal courts. So thank you for the well-briefed argument and your oral argument today.
And I thank you, Your Honor, for the opportunity to present argument and the opportunity to appear in Fremont County, which is a great courthouse. Thank you.
All right. Thank you, Ms. Olson. Mr. Wood, I will allow a rebuttal argument just from the state at this juncture based on the posture of the case and the comments you made at the beginning. If you have any rebuttal, it's not required, but if there's anything you'd like to add, I'll hear that now.
Just very briefly, and appreciate counsel's comments. The Mr. Pryor did bring up a point that I put in the brief but did not bring up, but it is important to note. And Ms. Olson addressed it as well. And the state's position is by broadcasting a trial, it only makes it easier for potential witnesses to make a mistake of seeing something they shouldn't see, of hearing something they shouldn't hear. At the last trial, this issue came up with a few witnesses, and that was just the audio. The state sends out something with every subpoena. We communicate to every single witness, you're not to watch or listen to any of this trial. Sometimes things still happen, and then we have to deal with that in court, and it takes time away from the jury, it takes time away from litigating the case. This is a long trial. I don't know if it's true. I've heard that the preceding trial in this case was the longest criminal case in Idaho state history. I don't know if that's true, but I've heard that. But this will also be a very long trial. This will probably be a longer trial. Broadcasting that length of a trial, we just really run the risk, no matter what we say to witnesses, of people hearing things, seeing things they shouldn't. I know just a couple of things from Ms. Olson's comments. And I probably didn't write this down exactly how she said it, but she mentioned that we live in a day and age of visual coverage of everyday life. I don't know that that's really an argument for broadcasting a trial. I don't know that that's a good thing. And we could probably spend hours talking about all the social implications of the fact that we live in a day and age where everything is televised or put on a computer or a phone, and there's videos of everything everybody does. I don't know that that's really an argument that we should contribute to that. I don't think it's a good thing. I don't think it's a good thing to turn everyday life into a circus. And I think that broadcasting, even if done responsibly and respectfully, will contribute to that. I just finally end on noting, she mentioned the Kyle Rittenhouse case. I brought this up the last time we litigated this. It's interesting because that judge said afterwards, and I quote, "I'm going to think long and hard about a live television trial again next time. I don't know. I've always been a firm believer in it because I think the people should be able to see what's going on. But when I see what's being done, it's really quite frightening." That was Judge Schroeder from the Kyle Rittenhouse case. My understanding is he said that in regards to the context of a jury bus being followed by some reporters. And we're certainly not alleging that any of Ms. Olson's clients are going to do that. But the reality is by broadcasting, we absolutely will create more of this circus type environment, more of this reality TV environment, this true crime obsession. Again, we believe the media should be there. They should report. They have a right to be there, and the public has a right to have the media there. The public has a right to an open trial. We would ask the court to maintain its current order. We believe it was a good decision then, and all the reasons that it made that decision then still apply today. Thank you.
All right, thank you, Mr. Wood. All right, counsel, I've been considering the decision on this issue. I am prepared to make a ruling today. However, I do want to take a quick recess to sort of gather my thoughts and prepare for the ruling on the motions. So we'll take a recess here for about 10 minutes or so, and then I'll come back on the bench with the ruling.
All rise.
This has been a special report from True Crime Today and the Hidden Killers podcast.